Good morning, Michael.
Good morning.
How are you?
I'm doing great. Thank you.
Thank you so much for joining us today. And we're truly grateful for you to be here with us and sharing your expertise.
Well, my pleasure.
First of all, could you please introduce yourself for our audience?
My name is Michael Strauss. I am an attorney practicing in Ventura County. I've been practicing employment law for the last 16 and a half years.
Thank you. Because you're an expert in employment disputes, could you please clarify for our audience who's watching this abroad, what are common types of employment disputes you have here in the US?
Sure. So I represent employees, and typically employees who have disputes with their employers. It is with regards to compensation issues. For example, someone does not believe that they were compensated correctly. For example, uh, a salesperson who may have earned a commission, but his employer refuses to pay the commission. That would be a typical compensation related case that I would handle. Also, there are laws in California protecting against discrimination, harassment, or retaliation against individuals who are in protected categories. For example, you cannot discriminate against a worker because of her sexual orientation, her gender expression, um, her race, her age, her ethnicity, things like that. So if an employer discriminates, harasses, or retaliates against a person like that, then that person would have an employment claim against their employer. And so I would do that. Um, the majority of my career, however, has been made up of class action lawsuits. So I represent hundreds of people who have the same types of claim against their employer. And a classic one of those would be a claim where the employer did not pay all of the employees for all of the hours that they work. And so I will sue on a class action basis and try to recover money for all of the employees at the same time.
Thank you. I have never heard about retaliation before coming here.
Yeah, so a typical retaliation case, and this happens somewhat frequently, is if, let's say, you know that your employer is engaging in some kind of illegal activity, and you tell your employer, "Hey, I'm going to go and tell the police because you're violating the law," or "I'm going to go tell the Department of Labor that you're violating the law," and your employer retaliates against you because of that. That type of claim is unfortunately somewhat common.
Mhm. Is it possible to resolve such disputes using mediation? And what benefits of using mediation as opposed to going to court?
Yeah, absolutely. Virtually every dispute can be resolved through mediation. Employment disputes are not an exception to that rule. And so oftentimes parties will mediate before a case is filed or after the employee files a case in court. Either the judge will tell them that they must mediate, or they'll agree that the parties will agree that they need to mediate or would like to mediate. And so you can essentially mediate one of these disputes from its inception all the way through, the day that maybe even after a trial of the case. There's always an opportunity to resolve the case. It just depends on both sides wanting to um, come to the table to resolve.
What about benefits of mediation as opposed to going to court or
Absolutely.
using another dispute resolution tools?
And absolutely there is. For the employer, let's say that you as an employer know that there is some information you don't want exposed because it could end up hurting your defense. If you mediate before a case is even filed, you won't allow the other side to conduct the discovery that they need to be able to assess the evidence to see whether or not your case is worth more money. So essentially, an employer can get out of a case for less money, I think, if they mediate early. Now, of course, the plaintiff has some benefits too, and it could work the exact same way. If the plaintiff knows that there are certain weaknesses in his or her case, they can try to mediate the case before anyone's deposition is taken and before that information comes to light. And so both parties can benefit by coming to the table early if there is some information out there that they don't want the other side to ever know about.
Thank you. Because not everyone familiar with mediation, could you please walk us through your typical mediation process from start to finish, just to have general understanding?
Yeah, of course. So a mediation is a chance for the parties to come together to see if they can resolve their dispute. As a mediator, I'm the one who helps the parties realize the risks that are involved in their positions and hopefully facilitate them in reaching a resolution of their case. So as a mediator, I get involved when the parties agree to use me. And so I'll get an email from one of the parties' attorneys saying, are you available? We'd like to use you. And do you have any available dates in the near future where you can act as a mediator? So once we secure the dates, I'll send out a contract. They sign the contract. The contract essentially informs them how much I cost. And it also lays out confidentiality. Confidentiality is a linchpin of the mediation process. Everything that happens in a mediation is confidential. So the mediator can never be used to testify in court as to what happened at a mediation. No documents exchanged at a mediation can be used in court. There may be other ways to get them outside of a mediation, but the information that you glean in the mediation itself is not discoverable later on. So once the parties agree to the confidentiality terms and we picked a date, the parties will submit briefs to me. Briefs are hopefully about 10 pages long. They'll explain the legal position of their claim or defense and the facts that support their claim or defense. And so at that point, they try to persuade me as to whether they have a better case than the other side. So as the mediator, I'll review both the briefs. If I have any questions, I'll reach out to them to clarify their positions. If not, we will show up at the mediation. Most mediations these days are held by Zoom. And so I will convene a mediation by Zoom. The parties will all appear remotely. I will usually start in the plaintiff's room and get more information from the plaintiff and see if I have any questions that can be answered at that time. Once I get that information from the plaintiff's side, I'll then go into a room with the defendants. Keep in mind that even though we're on Zoom, everyone will be in separate rooms. And so I will transition from one room to the other to talk with the parties separately. And so once I talk to the defendant, I'll get their position and learn a little bit about their case. I'll go back to the plaintiff's room and discuss it with them and ask them to come up with a number, a demand that is reasonable, that can lead us in the path towards a resolution. And once I get that number, I'll take it to the defense side and we'll talk about it. And hopefully they give me a counter. And then I will go from room to room, conveying dollar amounts of offers and demands, and also explaining to each side why I think they should consider coming off of their number, whether that's coming up for the defendant or coming down for the plaintiff. And eventually, hopefully, we will get to a very narrow range, and I'll be able to either propose that they split the difference or something near there, or even get them to agree to a number on their own without having to propose it. And once we do that, we'll have a settlement, and then the parties will exchange settlement agreements. Sometimes that happens at the mediation, sometimes it happens afterwards. And when I feel like the mediation is over, I'll say my goodbyes and turn off the Zoom, and the parties will go their separate ways. If the case doesn't resolve, they can usually reach out to me and have me resume discussions with the other side to see if there's a possibility of reaching a deal in the future. And so I oftentimes will have these post-mediation communications with the attorneys to see if we can bridge the gap that remains outside the mediation.
Thank you. And just to clarify, do you conduct joint meetings or only caucus sessions?
I only do caucus sessions. Yeah. I mean, there always could be situations where the parties would benefit from having a joint session, but in the employment mediation world these days, it is extremely rare for there to be joint sessions.
Okay. And what's your advice for parties who decide to use mediation? How can they prepare for successful mediation sessions?
Yeah, it's a good question. Preparation is key for a mediation. The way that you prepare for a mediation is to take it very seriously. Some people think, I've got a mediation on calendar. I don't have to do any work in my case until the mediation. That's not true. You should be contacting your witnesses. You should be gathering all the documents. You should be preparing your case as if you were going to trial, because the more information you have, the better your arguments, the more likely it is you'll be able to convince the mediator to, I don't want to say take your side, because mediators don't take sides. They're neutrals. But if you can convince a mediator to that your position is correct, that mediator can use that information in the other room to get them to move from their position. And so the more prepared you are in mediation, the more information you have, the better your legal arguments, the more likely it is you'll be able to convince the mediator that you are correct and your opponent is not. And using that information, the mediator can then go and convince the other side that your case is better, and therefore perhaps the defendant should pay more money, or the other side should pay more money. It's not always the defendant.
Thank you.
Yeah.
How to be if employer believes that the claim has no merit? Should employer participate in mediation or not?
Almost every employer is going to say that the claim has no merit. I think that if the employer really thinks the claim has no merit, the employer should try to resolve the case very early on to avoid having to go to mediation or to court. Maybe there's a chance that you could settle the case for very little money without using a mediator. So I would suggest to that employer that they attempt to resolve the case informally before mediation to see if that's a possibility. And so if you can't resolve a case informally, then perhaps the next step would be mediation.
Thank you. How do you handle power imbalances between employees and employers during the mediation sessions?
There's always a power imbalance. Obviously, employers have more power than employees. Maybe the larger the employer, the more power imbalance there would be. Because sometimes a small business may not have the money to pay a settlement. And so let me give you an example. Let's say an employee has a really good case for an unpaid commission of $100,000. They know they are owed $100,000. The contract says they're owed $100,000. There's really no defense to them being paid $100,000, but they're mediating with a small business that doesn't have $100,000. So in that situation, The employer may have a power imbalance. The employee may have more leverage than the employer. And so your question is, how do you deal with power imbalances? Having the parties in separate rooms, caucusing in separate rooms, keeps them from asserting power over each other, at least with their bravado and the way they speak. I don't necessarily have to tell one side what the other said to me in closed session. And so let's say, for example, the employer says something that is demeaning or reflects the power imbalance. Like, we're going to crush this guy. I don't care how much money it'll take. We're going to crush this guy. Something like that. I don't necessarily have to tell that to the other side when I go talk to them in their room. So there are definitely ways to maintain control and not have a power imbalance that drives the mediation. And a lot of that has to do with how I communicate from one side to the other.
Thank you. And we all want to hear some examples of mediation. Can you describe one of your most memorable mediation cases without disclosing any names?
Yeah, I could try that. So I've been a lawyer for a long time, and I've done many mediations as a lawyer. And I have very memorable situations of mediating big cases, big class action cases where the dollar amounts being discussed at mediation were jaw-dropping. But as a mediator, I think it's funny to, maybe not funny, but it's interesting to me that you can mediate a case over very little money and the emotions are greater than mediating a case where the amount at stake is in the tens of millions of dollars. And so a recent case that I mediated, the settlement amount was in the four figures, and it took, we were making moves of $100, $200 each, and it was a struggle to get the parties to move even that little. It was a case where it was unclear as to who would be liable. So sometimes in California, you'll have two people or two companies can be liable for owing wages to one person. It's called joint employment. And so it happens a lot on a construction work site where you have a prime contractor who hires out different tasks to subcontractors. And so the subcontractors will have their own employees and they'll work on the project. The prime contractor is just there to supervise all of the subcontractors. And so if the subcontractor fails to pay the employee has the option of going after the subcontractor and the prime contractor, or maybe even just the prime contractor. And so in this situation, in this recent mediation, the case didn't settle for a lot of money, and largely due to the fact that it was unclear whether the employee could sue the business as his employer or not. And so anyway, it was interesting. It's always interesting getting to debate legal issues, but it's also really fun to see how difficult it can be, even when the amount at stake is very little.
Thank you. And all ADR specialists, mediators wonder, how can we encourage people to use mediation?
That's a very good question. And I would say that the key to getting people to use mediation is the cost. Mediators in employment law in California charge an outrageous amount of money per day. And so it would be a low-priced employment mediator who would charge $10,000 a day for his or her services. And so you, as an employee or as a small employer, if your choice is to, if you're deciding whether to mediate and you're looking at, well, my lowest cost option is a $10,000 mediator, it's just not worth it to me. I'm going to see if I can resolve the case outside of mediation. Now, if your decision was whether a $2,000 mediator or a $1,000 mediator were an option, it would make it much more easy to decide to mediate, especially when the parties are splitting the fees. So cost of mediation, I think, is the largest driver of whether parties are going to mediate or not, especially for folks who don't have a high income. Let me give you another example. If you, as an employee, have a case that's worth $20,000, dripping wet, let's just say that's the total liability or the realistic settlement amount of your case is $20,000. You have to wonder, well, how much am I going to pay my attorney? Usually the attorney will get a percentage of your recovery. The percentage is usually between a third and 40%. So if it's $20,000 and the attorney is going to take 40%, well, that's $8,000 is going to go to the attorney. $12,000 will go to the employee. But if you have to pay for a mediator and it's a $10,000 mediator and you're sharing the cost 50-50, that's $5,000 that will come out of the $12,000 that the employee would end up getting. And so the employee would only get $7,000. The attorney would get $8,000 and the mediator would get $5,000. So under those circumstances, it wouldn't make sense for the employee to mediate. So again, a low-cost mediator would be great, a great driver of mediation services. But mediation, at least in my world, employment litigation, is usually for cases that are of a decent value. Otherwise, no one would choose to mediate.
Thank you. And finally, in your opinion, how can the mediation process be improved? Except the price of mediators.
Mediation could be improved in a couple of ways, or at least one main way. Having an accreditation system for mediation that actually means something would be a great way to ensure that the mediator that you choose is qualified. So right now, anyone who wants to be a mediator can be a mediator with no certification process. There is DARPA certification, but it isn't necessarily for employment law mediations or personal injury law mediations. It would be really beneficial to the system if there was some kind of certification process. I am a certified employment law mediator, for example, and that meant that I had X number of years of experience. I've done X number of mediations. I've done, X number of hours of training, that kind of thing. If there was a certification process, you might have a greater quality control for the process itself.
Thank you again for your expert opinion and your time. We all appreciate this.
No problem. No problem. Good luck with your project.
Thank you.